Good morning. The development of compulsory property is a long issue. It is being discussed on every suits and women folk are driven from time to courts up to New Delhi Supreme Court and resetting lapse of long years to get their share. And everybody knows the Gurupada Kandappa Magdam versus Hirabai Kandappa Magdam. This is a case of AR 1978 SC 1239, which was taught when Hindu law was taught to us during our law college days, wherein the Hirabai claims one independent share on behalf of her husband, and the husband share be devolved on the other legal heirs, and Hirabai also claims share being a legal heir of her husband under section 8 of the Hindu Succession Act. This is a vital question to be understood, and probably this may be multiply being fought legally fought on consequent days, and if still the compulsory properties are in existence, because after 2005 Hindu Succession Act has been drastically amended, giving daughters also equal share. So the question arises, when compulsory properties are being divided, only is a question of survivors, male survivors, plus 2 up, plus 2 down, middle the karta of the family. So accordingly the court held that the notional partition as elicited, notional partition is a word elicited under section 6 of the Hindu Succession Act, to be understood that the partition of the person, male person, should be parted from the main property of ancestral property, and accordingly as if he is alive. Thereafter, when he is alive, his wife was also alive, being the shareholders of the properties. So this was the case, this Gurubada case. Similarly, this case was subsequently went up to Supreme Court from Chhattisgarh. AR 2023, Supreme Court 4180, AR 2023, Supreme Court 4180, Hindu Succession Act section 6 and 8, Mitaksara compulsory property subject was deeply discussed. Here what actually happened, the Panuram Sahu died in the year 1959. So he left Kasarbai, daughter, through his first wife, and second wife is also having children, and there was a partition affected, and the Kasarbai was denied his 1/3 share on behalf of Panuram Sahu as a only survivor. So the suit was filed. She claimed 1/3 share on behalf of Panurams, and the rest of 2/3 share being parted between the other legal heirs, and Kasarbai is also entitled. This is the suit decreed on behalf of the Kasarbai, who subsequently died. His son was the legal heir. So that 1/3 share was allotted to her. This case was very short, but however deeply discussed about Gurupada Kandappa Magdam case, as well as Shyami Devi versus Manju Sukla case. This is AR 1994. Kindly go through the judgment. This is most important. We are preparing for examination for judicial officers, and also to understand the Hindu Succession Act prior to 2005. Best wishes.